Hello, everyone. Welcome to this month's Health Law and Ethics Network seminar. I'm Professor Paula O'Brien, one of the directors of the Health Law and Ethics Network. I'm very pleased to welcome everybody here today. We've got a really great crowd in the room and a large crowd online. So I'm really pleased to welcome Bill to speak today. So Bill Madden is here teaching in our master's program. He's teaching medical litigation this week. And we have a lot of his students in the room, so thanks for coming. And Bill today is going to talk to us about the implications of a very recent High Court decision, a decision which extended the concept of non-delegable duties to intentional acts. And Bill is going to be talking about the implications of that decision for the liability of hospitals and other medical organisations for the acts of health practitioners. So we appreciate Bill taking the time to do this and also taking the time to talk to us about a topic that's, very new and going to be very significant in many fields. I'd like to start by acknowledging that we meet on the lands of the Wurundjeri people of the Kulin Nation and pay my respects to elders past, present and emerging. So many of you will know Bill, but just to give you a little bit of background. So Bill has been a senior fellow in the Melbourne Law Masters for many years. He's also an adjunct professor at QUT, and he's an author of many papers and books in the field of medical liability. So we're extremely pleased to welcome him here today. If you don't know, Bill has a fantastic blog about civil liability law issues that I really commend to all of you. And so, Bill, I'm going to hand over to you.
Thanks, Paul. Good afternoon, everyone. The topic for today really is a topic about a High Court decision, which is primarily to do with historical child sex abuse. And so what I was trying to do with that is to then see what the ramifications might be in the medical context. It's a topic which is still fairly new, so we're sort of learning as we go. As you'll see from the slide there, I've been involved in a presentation on this once before with Tina Coburn, who's in the room today to correct me for when I make mistakes, who's a professor from QUT, and also with Ruanne Brell, who's a lawyer with Avant, the largest of the medical indemnity insurers. Just to put this into context, I suppose, and to maybe make us think about whether or not this is really all that much of an issue. It was in April of this year, so only last month, that AHPRA decided to roll out a change to the information that it has on its regulatory database for health practitioners, so as to permanently record on their register, on their records, information about I guess what you would call professional misconduct cases involving sexual misconduct. Now, those bits of information have come up from time to time in the past, but they also then tend to disappear. And what AHPRA has now done is it's sort of in a backdated way, has gone back to 2010 when AHPRA first came into existence. And it's put up the references to all of these cases for all of these doctors. So if you go to your own doctor, you can look up their name and see whether they've got that sort of a finding registered against their name for some form of sexual misconduct. Now, there were thought to be about 5,000 cases that AHPRA had to put up, which seems like a lot in itself. But then again, that's sort of over the last 15 years or so. But what is interesting is that since last year, 2025, AHPRA apparently received almost 2,000 notifications about boundary violations, including sexual boundary violations, so a 72% increase from the previous year. Exactly why, I don't know, but it does seem to suggest that there's some significance in looking at this topic of sexual misconduct and in that sense, an intentional tort. The AA decision is a de-identified decision brought by a gentleman who's been called for our purposes AA against the trustees of the Roman Catholic Church for the Diocese of Maitland and Newcastle in New South Wales. He said that he had been the victim of sexual assault by a priest within that diocese at a church. And just to sort of give you the sort of central point up front, what the court has done in this really quite important decision, it was all 7 judges of the High Court, and they took quite a while to hand down the decision before they came up with a result. They've done 2 things, really. One of them was the point that Paula made, which was that they've extended this concept of non-delegable duty liability to intentional acts, not just negligent acts, and we'll come back to that. But what they also did was they extended the scope of the categories to which non-delegable duties might apply. And what they did essentially was they said, well, look, we're accustomed to a non-delegable duty in a school pupil scenario, but we're going to extend that by analogy to a situation here where we've got a religious organisation and a child in the care of a religious organisation. Now, I'm not saying that the child was at a religious organisation's school. The child was actually at a state school, but had come into contact with a priest at the state school and then had gone to the local presbytery, which is where the abuse was said to have occurred. So there were 2 extensions. There was the extension in relation to the category, religious organisations, and there's a question mark as to whether it's only religious organisations. And then there's the question about intentional acts. So if we sort of jump around a bit, it's probably worth talking about what a non-delegable duty is. And there's some text on the slide there which I realise is a bit heavy, but I'll just give people a moment, if you don't mind, to just read the first paragraph, number 21. Now, this is a quote from AA itself, from the plurality judgment, and you'll see that the distinctions made between a duty of care in negligence, which requires the holder of the duty to exercise reasonable care, but a non-delegable duty is more than that, in the sense that the organisation can exercise reasonable care, but nevertheless be liable because of something which is done by their delegate. And there are some features of that to do with vulnerability that we don't need to worry about too much for today's purposes. Sometimes people describe non-delegable duty as strict duty, and that's sort of right in the sense that although the organisation can delegate a task to someone else, they can't then escape liability necessarily if that person, the delegate, is negligent in the way they carry out the task. Or, as we now know, in the possibility that they do something wrong in an intentional way. But it's not an absolute duty. You know, if Mr. AA had simply gone to the presbytery and the ceiling had fallen on him for no apparent reason, with nothing to do with the acts of the diocese, then the church wouldn't have been liable for that, because there's no action on the part of the delegate in those circumstances. So let's go back, because we have to tie this to medical for the purposes of today. Justice Gleeson, although she was in a minority in the judgment, did summarise the traditional non-delegable duty relationships. And you can see there's some unusual ones, owners of land who might have an obligation to the people next door, employer and employee, which is a common one, and the one that's we're familiar with in the AA context, school authority and pupil. But also hospital and patient, which is what we're interested in today. And in some circumstances, the occupier of some premises, in the event that they're involved in extra hazardous activities, whatever that might be. So you need to look at that on a sort of case-by-case basis. So if we go back and look at the common starting point for non-delegable duty cases in Australia, I think most people start with the Albrighton decision. And you can see that Nygar Albrighton was a 15-year-old girl. She was admitted to Royal Prince Alfred Hospital in Sydney with a view to having surgery on her spine, which had an abnormality. And the case sort of went around the circle of the treatment that was provided to her. She was given traction. She was referred for attention by a neurosurgeon. And what seemed to happen ultimately was the neurosurgeon looked at the notes and said, well, okay, she's in traction. I'll go and see her in a few days. But that was a problem because that meant that no one was looking after her for those few days, and there was a delay in treatment of her condition, which resulted in her ultimately suffering paraplegia. The name change was because when she was a child, her surname was Zengen, and then she was married by the time the matter went to court, and hence the Albrighton surname. Now, this was an interesting little case when you actually go back and look at some of these older decisions, even in the 1980s, because it tied into what ought to have been done at the trial by a jury. A jury had been given directions by the judge, which limited what the jury was able to focus on. Juries are often given directions where they're told, you look at this, don't worry about that, that's for somebody else to worry about. This particular appeal was really an argument primarily about what the jury had been told. But nevertheless, in what really is a very short judgment, you can see that the Court of Appeal has said that this particular issue about the liability of the hospital ought to have been left to the jury. The jury should have made a decision about that based on evidence about the relationship between the hospital and the doctors and the patient in this particular instance. And most of you will be aware that there's the traditional starting point for that is when you're dealing with an organisation, is the organisation vicariously liable for an employee? Now, the surgeons were not employees, or at least one of them wasn't. And so the question which then arose was, well, could the hospital be liable anyway based on this non-delegable duty principle, which had been recognised back in England in about the 1950s, but didn't get a lot of attention in Australia. And the Court of Appeal in this particular matter said, yes, it could. There was a non-delegable duty. And you'll see the quote there where the judges have said, or one of the judges has said, the patient became a patient of the institution which undertook to render her complete medical services through its staff, all chosen by them, not by her. So she didn't choose the doctors. She basically went to the hospital and the hospital said, these are the people that are going to work on you. And so in those circumstances, the hospital was responsible for the work that was done by those staff, whether they were employees or whether they were contractors. Just an aside, I noticed that in this decision in 1980, junior counsel for the plaintiff was a young barrister called Tom Bathurst. Tom Bathurst eventually became the Chief Justice of New South Wales sometime later, although he's now retired from that role. So that's the Albrighton case, and that's the sort of leading case for non-delegable duty. And it's obviously only a New South Wales Court of Appeal case, but there were a couple of High Court cases where there were references to the non-delegable duty in a hospital context. Probably the best example is Commonwealth and Intravene, a 1982 case, where you'll see that Justice Murphy, who's a judge who doesn't often get referred to these days from the High Court, he made reference to some commentary in an academic text, Fleming's Law of Torts, a famous book, and he said, yeah, non-delegable duty can certainly be owed in a hospital patient scenario. Qantas is another case along those lines. Now, if we just sort of pause there for a minute, what we've been talking about in relation to non-delegable duty, and particularly in Albrighton, was obviously not intentional misconduct on the part of the doctors. The surgeons were negligent in the way they treated or didn't treat this young lady, but they weren't intentionally doing anything wrong. Which brings us to the case which caused the problem with this sort of intentional approach or non-delegable duty in an intentional context. And that was New South Wales and Lepore. It was, in fact, 3 different cases, all taken to the High Court to try and deal with the same issue in a school setting. And you can see from the summary there, 3 appeals, sexual abuse of pupils by teachers, and the issue was the non-delegable duty issue. And it was a bit of a messy decision. It was a decision which I think a lot of people have over the years made critical comments about. And it's always difficult when you're dealing with a High Court matter where the judges don't agree amongst themselves. And they don't agree in a sort of untidy way. So you'll see here that Justice Gleeson, who was the Chief Justice, and 3 others said that there could not be non-delegable duty if the act that we were worried about, the act of the delegate, was an intentional act as opposed to a negligent act. So this sort of left us in a scenario, if we just think about schools, where if there was somebody who wasn't an employee, they were a subcontractor, if they did something which injured a child which was negligent, the school was held responsible. But if they did something which injured a child which was intentional, the school wasn't responsible. There might be other bases on which you could argue that the school should be responsible if they had, for example, not properly interviewed the teacher. They're back there, they had a track record that hadn't been looked into. But just ordinarily, the school wasn't responsible. And the law stayed that way for the next, from 2003 to 2026. Now, in the meantime, there were occasional medical cases which sort of touched on the Lepore decision and non-delegable duty. One of them was NB, and you'll see that a young woman was being treated at Liverpool Hospital after she'd had a hemorrhage, and she said that she had been essentially sexually assaulted or indecently assaulted by somebody working in the hospital who was an orderly, wheeling beds around, doing sort of handyman type tasks within the hospital, not a medical practitioner. And NB argued that the hospital was negligent because of the circumstances, and the trial judge there made some comments about Lepore and made a quote and quoted something from Justice Gaudron. But to be honest, looking back over it, it looks like something that's perhaps been written a bit quickly. It doesn't really seem to make sense when they were talking about someone who was an employee, but they were referring to Lepore, which was a case about non-delegable duty by someone who wasn't an employee. So NB is a bit of an unhelpful case. There was an English case, by the way, just as another example on the side where this issue might arise, which goes to show that we don't have to be concerned about sexual assault as the intentional act. And in this particular instance, Mr. Bramhall, who's a transplant surgeon, pleaded guilty, having been found, it was found that after he had done the surgery on his patients, and in this instance, for example, put in a new liver, he would use his cauterisation tool to put his initials on the liver in much the same way that you might sign a painting after you'd done it to indicate that you were the artist. No one knew about this, of course, because after he'd done this, he would sew the patient back together and they wouldn't know about it and no one else would know about it. but one of the patients needed a follow-up procedure and had to be opened up. That was done by a different surgeon who said, essentially, why does this liver have initials on it? This seems inappropriate. They are not made this way. They don't usually come out with a brand. They're not sponsored by anyone. So the surgeon admitted that he had done this. The patients probably came to no great harm, but nevertheless, it was an intentional act. It wasn't negligent. And it's, I suppose, an example of something where a non-delegable duty might have been useful. So we come to 2026, February of this year. The case was heard partway through last year. I thought it was a very interesting case, so I went down to watch. And it was a High Court's always interesting, as you can imagine. And it took the judges a long time, to my surprise, to hand down their decision. But let's just look at the facts of the case again so you don't get lost. The court accepted ultimately, pardon me for a moment, the court accepted that AA, who was then 13, had met the priest in particular circumstances through the state high school, that he'd been invited by the priest to the presbytery where he lived. And this was some sort of social visit on a Friday night. It wasn't a formal social visit. It wasn't like a little group of teenagers that would go there as a church group or something like that. It was less formal than that. And the priest apparently offered the boys, there were only 2 or 3 of them, alcohol and cigarettes. And he allowed them to gamble using a poker machine, which he kept in the bedroom in the presbytery. Exactly why he had a poker machine in the bedroom in the presbytery, I'm not sure. That sounds like something that some, should I say, Irish Catholic traditions might have permitted, but might not be expected in other circumstances. But there was no harm from that. But AA said that he was sexually assaulted by this man. And now this man, of course, had died many years later. The diocese was not negligent. The diocese didn't know about this happening. There'd been no failure on the part of the diocese in the hiring of the priest, the appointment of the priest. There'd been no prior allegations of misconduct against the priest. So you could not say that the diocese was of itself negligent. Secondly, so the church was not of itself negligent, the diocese was not negligent, and nor could the diocese be held liable for the acts of the priests on the basis of vicarious liability, because priests are not employees in the Catholic Church. They're not paid a salary. They don't get superannuation contributions. There's none of the usual trappings of employment. They're essentially, they're carrying out a religious vocation. They do what they're told. They're provided with some food and other incidentals, but they're not employees. And that wasn't really an issue. And although there'd been some debate about whether priests could be what was being called akin to employees, borrowing some English precedents, in Bird and DP, the High Court had said in 2024, no, vicarious liability requires employment. Let's not confuse the issue. If they're in employment, vicarious liability. If they're not in employment, doesn't work. So where does that then leave us? The only possibility for AA to succeed, obviously, was to say that the diocese was liable based on a non-delegable duty for the acts of its delegate, the priest. Now, the hurdles for that were twofold. One was that there was no precedent for a non-delegable duty owed by a diocese, a religious organisation. But the court said no, but by sort of an incremental approach, we can extend that principle pretty easily to a religious organisation. And majority were content to do that. And then the second problem which arose, of course, was what had been said in Lepore in 2003, that you can't have a non-delegable duty extending to intentional acts. In this case, intentional criminal acts of somebody who happened to be a delegate of an organisation. And you'll see that five of the 7 judges collectively said, we've decided that that law was wrong, we're going to change the law, and now the principle is that a non-delegable duty can extend to an intentional act such as this. So AA was able to succeed. So the question which then arises, I suppose, is, well, what do we do with this in a medical scenario? There was a case called AB in the Australian Capital Territory a few years ago. Young female patient said that she'd been sexually assaulted by a male patient. Does that really permit us to bring a claim against the Australian Capital Territory for the acts of a delegate? I suspect not, because the male patient was there as a patient, not as a delegate. They weren't doing work for the hospital in some shape or form. I mean, they may have been able to be sued successfully for negligence in not having appropriate systems in place to protect young female patients from male patients, in particular this particular case, who had a history of being abusive. He was affected by alcohol, by drugs. Clearly some security needed to be in place to protect her from him. But that's direct negligence. He wasn't an employee, he wasn't a delegate. So in that context, that, I think, claim would not have succeeded as a non-delegable duty case. What seems to be necessary is a pre-existing relationship between the organisation and the claimant, the plaintiff, for a non-delegable duty to arise, because, and you'll see from the quote here, but on the following slide, there's this sort of assumption of responsibility that needs to come into it. Now, an assumption of responsibility is easy to imagine in a school setting, and it's reasonably easy to imagine in a religious organisation setting, especially in some circumstances, but also in a hospital setting. And so we'll go forward and look at some of those. And there have been some cases where vicarious liability and non-delegable duty have been discussed, but not many. So in 2006, a private hospital in Sydney, quite a complicated case where Mr. Sherry died after he'd had a bypass procedure. And there was a series of arguments because the different people involved had different roles. So some of them were employees, they could be sued for vicarious liability, but the ones who weren't, the ones who were effectively subcontractors, could be sued now, and even then, as delegates for negligent acts. There was only negligent acts here. There was no particular focus on intentional acts. There's a day procedure clinic case. Ardlog Pty Limited, trading as Australian Birth Control Services, was essentially a clinic that was providing pregnancy terminations. So it was sort of not as big and fancy as a private hospital, but nevertheless providing medical services. The doctor was engaged as a contractor. He wasn't an employee. And even though in this case the trial judge didn't firmly conclude that there was a non-delegable duty owed because of the references to vicarious liability in the judgment, I think it's perhaps one of those cases where the judge hasn't been given enough information to really drill down on that fairly carefully distinguished issue, and it should have been decided on a contractual basis, non-delegable duty basis. Again, no intentional act. Rooty Hill Medical Centre, so an ordinary GP practice, medical centre scenario. Again, it wasn't clear whether the doctor was employed or was just a contractor, but it was one or the other. And so to that extent, the judge essentially said, well, the medical centre can have a non-delegable duty. So I suppose the point of these three cases, and there's one more in a minute, is we're not just talking about big public hospitals that have non-delegable duties. We're talking about private hospitals, clinics, and possibly even an ordinary GP practice could be liable. The one that I thought was interesting, because it seemed a little bit unlikely in a way, was a pathology service where somebody had gone in to give a blood sample. You don't have much of an opportunity to have a pre-existing relationship between the pathology service and the plaintiff, because they come in, they give a blood sample and they go. But nevertheless, it arguably could be extended in that way. So just going back a step, are there limitations? Are there things that we need to bear in mind that don't give rise to an easy argument about vicarious liability or non-delegable duty? And the leading case is a case called Ellis, and it's a sort of a bookend case. So it's the opposite scenario to Albrighton and Royal Prince Alfred. In Albrighton, the patient just went to the hospital and the hospital gave her the doctors. In Ellis, the patient had a relationship with the doctor already and said, I want you to come to Wallsend, that's where I do my surgery, etc. So there was this sort of direct relationship there. And to that extent, the hospital was not liable for the conduct of the doctor who did the surgery, but of course remained liable for the conduct of either other employees or other delegates, if I can use that word, contractors. So where does that leave us? It seems clear enough, I think, now that as a result of AA, in the event, and hopefully this is not something that happens very often, but in the event that there is a sexual assault by someone, obviously who was an employee, there may be liability based on vicarious liability, but there may be a person now who's not an employee, just a contractor, and the hospital or other medical organisation may still be responsible for an intentional sexual assault or some other assault. And it, as I said before, it doesn't have to be sexual assault. There was a case in New South Wales about over-servicing of dental treatment, Dean and Fung. That was clearly treatment which wasn't required, and that was arguably an intentional act rather than just a negligent act. Now, in that particular case, there was no organisation. It was just the patient suing the doctor or the dentist, but that sort of principle should apply. And it looks as though arguably public hospitals, private hospitals, day procedure clinics, general practices, apparently pathology services, and maybe residential care facilities, that sort of thing. Because if you can draw an analogy between schools and religious organisations, you can probably draw an analogy, I think, between hospitals and aged care facilities. Delegates, yes, obviously doctors who are delegates, but not just doctors who are delegates. There may be other people. In hospitals, as you're aware, there are a number of people who provide services voluntarily to help out patients, and it may be that they could be considered a delegate if they're doing tasks essentially at the request of the hospital. And certainly people who are under contract, even perhaps a cleaner might be in that sort of category. Another point that I wanted to make, and we're almost to the end, the delegate themselves does not necessarily have to directly cause the damage. That point was made in the AA decision where the court essentially said, look, if Father Picken had not assaulted the boy, but Father Picken's friend, who was there at the time, was sort of called in and he was the one who assaulted the boy at the request of Father Picken, that liability could still roll back to the primary organisation. We need to be a bit careful about the delegation of functions and how far it goes. And probably the easiest example to give to that, if we go back to AA, the boy AA was had a connection to the priest in the sense of some activity that the priest was performing for the diocese. Yeah, he was teaching scripture in a state school. And he was occasionally seeing young students to give them perhaps to some extent religious education. But there may be scenarios that connect to, say, priests, but have got nothing to do with the diocese. So if, for example, you know, I was to go and if I was a child and I go and visit my family home and my elder brother happens to be a priest and I'm assaulted by him, that doesn't make the diocese automatically liable. And similarly, in a medical treatment scenario, we need to find a way to tie the potential liability of the medical organisation to some existing relationship for medical treatment. So the point that I'm trying to make is just because someone is sexually assaulted by a doctor doesn't necessarily mean it's the hospital's fault. You need to look at the relationship. You need to look at how that came about.
Could you please join me in thanking Bill very much? So just to let people know, Bill's teaching this master's subject at the moment, but he's also teaching a subject, institutional abuse and legal redress, later in the year, if that's of interest to you. If you'd like to join the Helen mailing list, the Health Law and Ethics Network mailing list, and you're not on the mailing list, you can go to our website, on the Melbourne Law School website. And we have another seminar coming up on the 2nd of June, which is about the legal and ethical significance of bioprediction, foreseeability, control and responsibility. And it uses the case study of the Dalesford car accident where the driver was diabetic to explore these issues. So we'll see you hopefully for that seminar. So thanks again, everyone, and thanks, Bill.